Hello. Good evening from Mumbai, and good morning to those joining from the US, and good afternoon to the ones in Europe. A warm welcome to everyone, and thank you for joining us today. This symposium on publicity, privacy, and performance and personality rights, it comes at a very crucial time. In today's digital economy, a celebrity or a sports person image is not just personal, it's a marketable and a tradable asset, which is central to endorsement, to partnerships, and of course, the influencer economy, which is TikTok, Instagram, and all of that. And yet, the commercial use of identity raises pressing questions of ownership, of control, of misuse, and regulation. With jurisdictions like the US, EU, and India adopting very, very different approaches, our aim today is to reflect on these differences and explore the possible ways forward. And for everyone's benefit, I'll briefly outline the format. We have two panels, each featuring three speakers, and they'll bring perspectives from their respective jurisdictions. Each panelist will have around 6 to 8 minutes to speak, and the moderators will ensure that there is a balanced time and post linking questions. For audiences, they can submit their questions in the Q&A, which would be somewhere on the screen towards the bottom right. Also, please note that the chat window has been disabled. So, in case you have any questions, there's time allocated. We have 10 minutes for Q&A. Please type your questions in the Q&A box. With that, I once again welcome you all. And now I hand it over to Dean Ashish to take us forward.
Thank you, Simran. Thanks very much for putting this together. The entire conceiving of the idea, the bringing like-minded partners together. Thanks very much. So, welcome everyone. Those who are joining us from the US and from Europe. We are recording this entire symposium, which has two panels, and there are participants in the Zoom call, and we will also upload the recording on YouTube so that those who could not join because of any reason, they could view the proceedings later. So let me share a little bit about how we decided to come together to do this jointly. It's not by chance. It was a very carefully curated topic with two of our partners or institutions that are like-minded in terms of certain areas of law that we focus on. UNH, Franklin Pierce, is one of the first institutions we signed an MOU with for different avenues for partnership and for law students, law faculty. We've also hosted their faculty on our campus who delivered, I think it was Richard who delivered a masterclass to our students in Mumbai. And I've also had the pleasure of meeting Dean Tuck, and it's great to partner with them on a topic which is quite central to intellectual property law, which is a very important area of Franklin Pierce's work and expertise. The second institution that we've partnered with for this event, ISDE, is again a very niche, highly sought after institution in Europe now. They are a multi-campus institution, but I was introduced to their dynamic CEO, Juan Jose, by one of our common friends at Columbia Law School, and Adam. And after that, we started to talk about how we can not just raise awareness about contemporary issues, but also about our institutions among the larger student body. And that resulted in this symposium. So while the three countries where the three institutions are based, they're really separated. They're in three different continents, three different time zones, and we're separated by large land mass and oceans. But what we do share is our deep interest in very contemporary and interdisciplinary areas, including the topic for today's symposium: publicity, privacy, performance, personality rights, whole idea of property and intangible in the context of creative work. I'll also mention that BITS Law School is one of the few law schools in South Asia which offers specialization. And one of our areas of specialization is entertainment and sports law, which is an area that ISTE and Franklin Pierce they both excel in, which is why this forum is also to learn how they approach these topics in their legal systems and in their classrooms. So with that, let me dive straight into the first panel which I'll be moderating, and I welcome the panelists. We have Peter Foley and Maria Burgos Dorado from ISTE. Peter is from Franklin Pierce, and we have Vishwas Devaya. All three are professors, and Vishwas is a colleague at BITS Law School. The three of them will be sharing their perspective on the first thematic area, which is how do we conceptualize the right of publicity in the influencer economy. Now, before I ask the first question to all my panelists, I want to very quickly, for the benefit of students who are going to be the primary viewers or audience for this event, this symposium, I want to contextualize the theme very quickly. In entertainment and sports law, we, of course, talk a lot about IP law, especially copyright, but we also go beyond that, and the panelists will get into the details of it in a few minutes. We also get into moral rights. We talk about performers' rights. Trademark law plays an important role. And with digital presence of works that are artistic, creative in nature, even complex contracts play a very important role behind all kinds of sponsorships, endorsements, branding, merchandise for athletes and performers and musicians and artists. So it's a very, very fascinating field. Influencer economy, as some of you would know, is a relatively new, fast-paced, multi-billion-dollar industry driven by individuals, and they like to be addressed as creators, content creators, and they leverage social media platforms to build not only a network of followers, but they're able to monetize their content or their product or the services through different methods. So with this background, I want to welcome Peter. Very good morning. So let me, I was giving a quick context to our participants, and you've joined at the right time. I'm going to ask a basic question, same question to all three panelists. And please keep in mind that a lot of the students who are going to be watching this, definitely at BITS Law School, but maybe in your institutions as well, they're very curious to know what are the complexities when it comes to the influencer economy. How are the legal systems in our three jurisdictions handling these complex issues? So with that, let me ask the first question. How, and maybe we can start with Vishwas, if that's okay. And if you can shed light on this question, which I'm about to ask, basis your familiarity with the jurisdiction that your work is based on. how um, how does India, and for Maria, you could reflect on the same from a European perspective and peek into that from an American legal perspective. Uh, how does the right of publicity in a burgeoning influencer economy being contextualized in India? And if I may, part B of that question would be what kind of legal mechanisms govern these endorsement deals and brand sponsorships and affiliate marketing, sometimes even direct sales? Vishwas.
Yeah, I mean, you have an entire research paper out there uh, in your question. So essentially, let me kind of start with how India primarily kind of conceptualizes personality, right? Largely emerges from the constitutional provisions, more specifically from Article 21 of the Indian Constitution, where the courts have kind of read in the right to privacy includes the right to actually protect different aspects of your personality. Uh, and one of the reasons the court seems to have kind of articulated that right to privacy kind of also kind of includes the right to personality is because it is a form of your freedom of expression. It's a form of liberty, and any part of your personality, should kind of be, you should be able to kind of express yourself in your own way without necessarily kind of being restricted or in any way kind of impinged upon. So this is largely kind of emerging from a constitutional provision within India, right to life being extended to right to privacy, and right to privacy kind of being extended or being kind of broken down to kind of extend to right to personality. And when they're talking about right to personality, the court is fairly clear that this right to personality includes personal traits. It includes stuff like one's voice. It includes stuff like signature, performance, one's own name, one's creativity that emerges from one's own personality. So, as a matter of fact, as far back as 2003, the the highest court in the country, it did lay down that these are elements of your personality, and any violation of these elements can be protected under Article 21, saying that this is violation of right to privacy. So this is largely the basis or the foundation on which the Indian law seems to have actually taken off in 2003. And then subsequently, you had a bunch of cases that are primarily kind of gone on to say that this right to personality doesn't necessarily mean personality traits. When someone actually kind of takes up your public, publicly kind of uses your image without your consent, that extends to your personality, and you can seek relief within the specific provisions of our law, including constitution. There are statutory provisions in the form of different legislations. For that matter, the Information Technology Act, although doesn't necessarily talk in terms of celebrity law or doesn't necessarily talk in terms of personality rights, there are provisions within the Information Technology Act, like Section 43, which basically obligates any entity to kind of secure private details. If there is any leak in terms of private information, they are liable to pay damages. Section 666 of the Information Technology Act, more specifically 66E, says, it pretty much kind of ends up banning sharing of information, images without the consent of the individual. Section 72A brings out provisions which are primarily saying there are going to be legal consequences, and you might have to end up paying damages if personal information is in any way kind of leaked. So you can kind of make a linkage between data and personality out here, and essentially courts are actually willing to protect these aspects, especially when celebrities images, information is leaked or misused. You also have the possibility subsequently with the amendment to the Consumer Protection Act in India in 2019. There are provisions within the Consumer Protection Act which also kind of says that you cannot simply be using a celebrity's image, misappropriation of any information in the form of an endorsement is problematic, and it requires immediate remedies, but also obligates. It also puts out a duty on personalities and influencers out here by primarily saying that if you are personally involved in endorsing something which is false or misleading, you too have an obligation, and you might actually end up paying damages as well, right? And then, of course, on top of that, you do have provisions within your Trademark Act, wherein Indian laws have been fairly accommodative in terms of personalities, celebrities being able to kind of trademark certain distinctive elements of their personality, and if they've managed to do so, any misappropriation would essentially kind of bring they can bring action under trademark infringement. If they have not done so, if they've not registered their distinctive elements, they can still have the possibility of bringing tort actions under passing off. So essentially, we have a wide range of provisions, starting from Constitution, and then there are legal mechanisms like the Information Technology Act, Consumer Protection Act. You also have, ASCII guidelines, the advertisement guidelines, which also talk about certain obligations when you actually advertise. This might actually obligate private players when they actually misappropriate, celebrities or influencers' image as such.
Thanks, Vishwas, for that comprehensive overview of how Indian legal system and how Indian courts have contextualized the right to personality, right to publicity. Let me take the same question to Europe. So thanks for joining, Maria. I'm going in the same timeline. From India, we go to Europe, and then we will quickly hop over the Atlantic and go to the US to get Peter's deal. So same question to you, Maria. How does, and Europe is slightly more complex in this sense because there are several member states, but can you give us an overview of how Europe or perhaps Spain looks at right of publicity, and is it as complex as how India deals with it, based on what Vishwas explained?
Okay, thank you. So can you hear me, first of all? Yes? Okay. So the thing is that in Europe, and specifically in Spain, we don't have like a specific right of publicity regarding influencers. And the thing is that until last year, 2024, we didn't have any legal provisions that was related specifically to influencers. So I'm afraid I won't be that specific, but in fact, our legal regime is quite complex. So let's go into it and start studying that from other points of view that also touch the influencers era. So another criteria is that if you have published at least 24 videos in the previous year. So if you meet any of these requirements, you are considered a broadcaster, like, for example, Netflix. So you have to meet certain conditions in order to meet the right of publicity standards. Beyond this constitutional and civil framework, advertising regulation plays a crucial role. We have a General Advertising Act that establishes that the unauthorized use of a person's image in advertising is unlawful. More importantly, it forbids misleading advertising. Influencers act simultaneously as individuals and as commercial channels. When their content blurs the line between personal expressions and commercial communication, the risk of misleading consumers becomes really high. Also, this is reinforced by our Spanish General Audiovisual Communication Act, which, as I've mentioned before, explicitly recognizes certain influencers as audiovisual media service providers. Those who exceed these figures I've been saying have to complete like additional requirements. Also, influencer advertising must therefore be clearly identifiable. This obligation is not only statutory, but we also have self-regulation organisms. In Spain, our self-regulation most important organism is called Autocontrol, and Autocontrol has issued a new self-regulation code of conduct that is from this year, so it's going to be entering into force next month. And this states specifically how influencers should develop this right of publicity in this new era. There are certain really specific requirements, such as, for example, how to label the content which is promotional. And also from an enforcement perspective, we have an organism which is called CNMC, which is Spanish National Commission on Markets and Competition, which has emerged as a key supervisory authority. It processes consumers' complaints regarding influencers' practices, particularly in case of misleading endorsement.
Thanks, Maria. Let us move in that same path and hop over to the US. Peter, very good morning. Same question to you. How does the US look at contextualize and protect the right to publicity and performance?
Yes, good morning or good evening over there. Sorry for the lighting. I'm not in the witness protection program, in case anyone's wondering. I'm just on the road in a very old beach house that has very dim lighting, apparently. So, but I'm happy to be here. From the US perspective, it's I find it interesting what both commentators were saying about their country's approach, because the United States, for whatever reason, has a very different approach. There's no national federal law involving the right of privacy. Instead, the right of publicity. Instead, it is evolving on a state-by-state basis. Most states have some recognition of the right of publicity. It always stems initially from the right of privacy, but it's viewed now where it's recognized as a totally separate right from the right of privacy, because from the US perspective, it's not intended to protect the person from intrusion. It's intended to protect the person from a third party benefiting from their the fruits of their labors, in essence, and getting unjust enrichment from using their name, image, likeness, identity to promote products without that individual receiving any compensation. So that's the base point of it. State by state, California is the most significant state because of for cases, just because of the entertainment industry there. But it really does matter which state you bring a lawsuit in. Different states have different tests for whether there's a right of publicity violation. the normal issue is when an individual, if they're doing some type of creative work and they use the creations of another, whether there's a First Amendment protection for that invasion of their publicity right, and that turns in California as on whether the individual has transformed what the potential plaintiff has done into something new, a different creative work of art, or whether they have just essentially copied it. Different states have a different approach where they focus more on the economic effect as opposed to the transformational nature. So it results in, you could have two very different results in litigation depending on what state the case is brought in. As far as influencers go, there's I guess I would say influencers are people too, and potential plaintiffs. So all the rights of publicity, trademark, copyright would apply to them equally. Issues that I see coming up with that, however, is the question as to the awareness of those rights for given the youth of a lot of the influencers, and the accessibility to legal services to protect those rights. They're often dealing with kind of smaller impact in infractions where they're either some other user is taking their content and mixing it with theirs, or a brand of some sort is using their identity without them noticing, but it's all being done, like, for example, on TikTok, at such a level of broadness and speed that it's difficult for folks to keep up with when they're being infringed on. YouTube has a specific system that alerts people if they want to enroll in it. TikTok doesn't really provide much of protection for their participants. So essentially, the right to publicity is alive and well for all these influencers. But as I said, I think there are questions as to the extent of their awareness and access.
Thanks, Peter. Let me come back to India, and I will touch upon something that you said, Vishwas, towards the end of your remarks. You mentioned the courts defining personal traits, including voice, for example, in the purview. But I want to. We can't have an event complete without bringing up AI. We have to do that. With this influencer economy, we're also looking at use or misuse of AI-generated content, particularly the more disturbing use of deep fakes or synthetic voices, sometimes for financial fraud. How is AI-generated content being handled in India? Because it seems that the issues of consent, privacy, liability, all of them require a major rethinking.
Right. Thanks, Ashish, for bringing that up, because I was on a flight and I was primarily kind of going through a decision that came out yesterday. In fact, it was pretty much kind of involving some of these complexities, and it involves a very well-known personality. His name is Karan Johar, and there's a Delhi High Court relief given to him. It's an interim relief; it's not a final one. And it had the complexity of the case goes to the extent that there are 17 different, defendants in the case. It includes a defendant who is actually using, a synthetic media, which has his voiceover. It includes a synthetic media where someone is using his voice and his personality as a chat bot. It includes stuff like someone's using his images as posters that can be downloaded. It includes stuff like a Jiffy, as we would call it. I forget the expansion, but and lastly, of course, the usual traditional suspects of use of his image to kind of commercially kind of advertise a certain product, as if creating an association that Karan Johar has officially kind of endorsed this product. And of course, use of his, of synthetic media and the presence of the synthetic media on social media. So essentially, the court was actually forced to deal with 17 different defendants, and they're dealing with varied level of complexities. One is an easier issue of misappropriation of his commercial image for commercial purposes and denying him the right to earn revenues, right? So passing off trademark coming into play. But the complexity in terms of using his voiceover as a synthetic media and to appear as if he is speaking and having a conversation with someone, leads to all sorts of complex questions. And our Information Technology Act, while it's not talking in terms of celebrity rights or personality rights, it's definitely talking in terms, especially section 66 is talking in terms of varied aspects of fraudulent representation of a person, identity theft, impersonation. And what it does is it criminalizes as well and imposes penalties, right? Despite of this, one of the key elements is the fact that the person who's infringing, who's misappropriating the image, is an unknown entity, right? In fact, one of the key elements of the court has reserved the order is untraceable defendant, right? There is a domain name, and unless they get clear information as to who's owning the domain name, where are they owned, and in which jurisdiction they are actually present, the court is unable to resolve that problem. So therein comes John Doe. Doe, who is an unknown entity. So the order is actually kind of being given out, not just to the 17 defendants, but to John Doe, right? So essentially, it brings up a gamut of complexities within the Information Technology Act, within your traditional passing of trademark law, the Consumer Protection Act, where the court is also kind of observing that the fact that his image is being used and it is being you're misleading consumers, actually kind of and they've elaborated on the fact that essentially, if you're misusing a personality's image for a certain endorsement or an advertisement, a lot of followers, a lot of fans, a lot of individuals do believe in these celebrities, and that misleading element means they believe what these guys are saying, and this misleading might actually kind of lead to other consequences, right? So they are warning of the other kinds of dangers, including data theft that might arise, with a celebrity endorsing something, but there is an underlying link. You click on it, there's a bait. So you're primarily kind of possibility of other informational theft. So essentially, even Consumer Protection Act, Information Technology Act, and something that might come in the future, we do have a digital Personal Data Protection Act, which is not yet enforceable. But from the time it becomes enforceable, Section 6 of DPDP Act can have some major consequences on some of these players. Because especially it says consent must be free, specific, unconditional, unambiguous, and informed. So any kind of use of image without this consent, use of voice, use of face, might be seen within the realm of DPDP Act as personal information, sensitive personal information, especially if you're using, especially face for training biometric information could be kind of seen, voice could also be seen as biometric information. So it might impose certain obligations. And the more important element is, where are these actually found? These are actually found on social media platforms, and therein lies the quandary that players like Meta, in this particular case that I'm talking about, which came out yesterday, Meta was one of the parties to the case. So your social media companies are also being made parties. They don't have primary liability, there's secondary liability. They might have to actually kind of, the moment a notice is sent, take
Right.
down procedure might actually kick in.
Thank you, Vishwas. I, I, I really want to hear Maria's thoughts on this because, by the way, for our audience outside India, the Indian version of John Doe is called Ashok Kumar. But that's just a placeholder. Anyway, um, Maria, what's very, very interesting to me is I it's the problem of deep fakes is quite, I mean, it's pervasive, and all countries, all societies are trying to figure out the best way to handle them. I remember reading something last year when Spain had sentenced some school kids who had either created or disseminated some synthetic content, um, images of classmates, and they thought that it was being done in jest and fun, but it definitely infringed on what is now considered as victims of technology facilitated digital violence. I'm also quite fascinated by the fact that Spain has a dedicated ministry for digital transformation, and you have a digital transformation minister, which I think is quite remarkable. And now that in the context of EU's AI Act, I think Spain is considering some really stringent measures, uh, especially with penalties and not labeling the high risk the AI content. So, what are your views on the same question? How is Spain going about handling AI generated content?
Well, here in Spain, and not only in Spain but also in Europe, the AI-generated content has been slightly touched by the European Act, Artificial Intelligence Act, because of transparency obligations. We're going also to talk about this later, but first of all, to give you some context, here in Spain and in Europe in general, AI-generated content of created by certain person image cannot be used in advertising or in any other area without their clear consent. A deep fake that imitates a person's face or even just the voice without permission is therefore unlawful, even if produced by artificial intelligence. So, from August 2026, next year, the European Union Artificial Intelligence Act will enter into force regarding the transparency obligations. So, this European Act will require all companies to label all AI generated content, text, image, audio, or video. So the system has like two layers because it has to be marked with a machine readable tag in the metadata and also with a visible warner for users when they interact with AI generated content such as deepfakes or synthetic news. This rule is designated to guarantee transparency and avoid confusion about the origin or the authenticity of digital materials, and also specifically because we need to protect consumers and we need to know which type of content is made of real things and which one is not. So this act also makes a key distinction regarding e-read content, which only needs to be labeled when AI contribution is substantial enough to mislead about origin or authenticity. And in practice, this means that human editorial controls remains essential, specifically in news and commercial communications. So for advertising, the principle is clear. Content must never be misleading. And if an AI tool creates the false impression that a person endorsement a product, this would be both a breach of image rights and also a case of deceptive advertising. To comply, companies must develop certain protocols, visible and user warnings, permanent human oversight, etc. So in this case, consent remains essential and transparency is mandatory. A piece of AI-generated content becomes misleading advertising when it suggests false endorsement, for example, a deep fake of an influencer or celebrity promoting a product without this influencer or celebrity consent, and also when it hides the fact that it is AI generated. And you can also see it now in Spain that, for example, there are certain social media platforms such as Instagram that they already make you, because of their internal policy, tag all the contents that have been created with AI. Also, when it exaggerates qualities of a product or services using synthetic images or videos, and when it omits clear labeling required under the European AI Act or Spanish advertising law. In Spain, this would breach both General Advertising Act, which prohibits misleading commercial practices, and General Law on Audiovisual Communication, which demands transparency in all audiovisual contents. So, also, generative AI content can raise two major legal risks in Spain. First of all, it might infringe our copyright law because if it reproduces or transform sometimes protected works with the the inputs. Sometimes these inputs are illegal in our legal system because you cannot use a protected work as an
Right.
input, such as music, scripts, or visual arts. So even if the AI system creates a new output, the use of training data or substantial similarity to existing works can trigger liability under our Spanish Copyright Act. And second, it can also violate image rights when it creates a person likeness, which is the deepfakes. Or also in Spain, for example, we have had like certain social movements. For example, there is an association that is called PASABE that claimed, this association represents dubbing actors. So it claimed not to use their voices to train a artificial intelligence generative machine to create new voices. So this has been really serious in the cinema industry in Spain because for a time all dubbing activities were absolutely paralyzed until they reached an agreement. So yeah, that's it. That's
Right.
a current problem in Spain for sure.
Thanks, Maria. Peter, your fellow panelists have been so comprehensive that you have the easy task of sharing some perspectives on how the US is handling the menace of synthetic content, which is directed towards people, harmful content, deepfakes, for example. Can you share your thoughts in a couple of minutes?
Sure. Well, from a couple of perspectives, I mean, AI is obviously raising the same issues in the US as in India, in Europe. From a publicity right standpoint, again, the way it would be approached would have to be on the state by state litigation. This could be one basis for a movement to perhaps adopt a federal right of publicity in the United States in order to do something that would comprehensively address these AI issues. There is no proposal pending, but it would certainly be a helpful outcome in response to what is going to be most likely a deluge of litigation in these different states with potential different outcomes depending on the standards of different states. There's also been discussion at the federal level about prohibiting states from regulating AI. There was a proposal in recent legislation to do so. The states were able to mount a defense to that proposal, where it was going to be a 10-year ban on state regulation as opposed to federal regulation of AI. So right now, that did not happen. States are free to do so, but again, it would be on a piecemeal basis. For copyright, the U.S. Patent and Trademark Office is considering issues involving AI, and is involved in a rather long reporting process, and that has not yet been finalized, but obviously these same issues involving deepfakes and the creation of competitive artistic products raises an issue. From a publicity rights standpoint, I see a big distinction between AI deepfakes that are being used for commercial purposes, the false endorsement problem, where you clearly, if you can get it to court and find out who's actually doing the improper actions, you should have a basis for liability, versus AI deepfakes that are being used in a more kind of an entertainment setting, some type of creative output, where the argument would be they may be using someone's image, but they're transforming it in some way, and therefore have some right of First Amendment protection to their own AI creations. That there's been no case that has held that. I think it would be a difficult case to make unless the transformation of the individual is so dramatic that you don't really even at that point have a deep fake. So it's very much raising the same issues that you folks have pointed out.
Thank you, Peter. While I cannot think of any activity which is going to be better than discussing right of publicity and AI on a Saturday across the 3 time zones, I must pass on the moderatorship to my colleague Anandita. This is all the time we had. We overshot by 5 minutes. Sorry, Anandita, but I'm sure you can optimize. Before I pass it on to her, let me once again thank Peter, Maria, Vishwas for their time, and Simri, maybe we can get on a call later and discuss some of these things. I think there's a huge scope to think of certain research projects on these lines. Thank you for your time. Over to you.
Thank you.
Yeah.
A pleasure.
Thank you.
Thanks.
Yes, you were saying something, Simran? Okay. Thank you so much. Are we not going for the Q&A for the first session right now, or maybe we'll club it together?
We don't have
the panelists were so comprehensive that they preempted a lot of questions. That's what happens when you take meetings from a beach house, Peter.
Sure.
But if you wish to, hang around in the call for some more time, perhaps a question could be asked towards the end of second panel, could be directed towards the first panel. So, yeah, over to you, Anand.
Yes. Yeah, so placed at 3 different time zones on this Saturday. Thank you very much for joining. I would like to take a couple of moments to just introduce the August panel that we have with us today. So we have Professor Michael McKinn, who is the Associate Dean for Intellectual Life and Director of the Sports and Entertainment Law Institute, UNH Franklin Pierce School of Law. We have Professor Dev Kumar from ISDE, who is an academician and an international sports lawyer. So he has worked on kind of all aspects of representation, management, legal advice, pertaining to athletes and coaches. And we have my colleague, Ms. Simran Bajwa, with us, who is currently working as Research and International Partnership Associate at BITS Law School. She specializes in intellectual property rights, particularly AI, copyright, patent law, and she has extensive years of litigation experience to that. So I'll try to lay down a little bit of a context as we extend the conversation from the previous panel to the domain of sports now. So we are coming down to sports persons, athletes, and we are trying to talk about NIL and the P4, that is your publicity, privacy, performance, and personality rights in the space of sports law and sports people. So what started as kind of a right to be left alone, simply speaking, has now culminated into the NIL and P4 that we are talking today about. And primarily it has developed through courts and, judicial precedents. But initially what was only about name, image, face has now transcended to intangibles like gestures, signature steps, artifacts, tattoos, catchphrases, mannerisms. So it's about the entire personality that we are talking about and other intricate things which are intrinsically linked to the identity of a person. What I see making it more onerous in the contemporary times is trying to draw that line between what is an infringement or a violation of these rights vis-a-vis when can we call it a legitimate interest, public interest, commercial versus non-commercial use, or a simple fan page, which may be also taking pictures and images, but has no ill intent at the end of the day. So a couple of these, clarifications as to where to draw that line and what makes it more difficult in the sports space is perhaps the numerous relationships that come from contracts. So we have the individuals and then we have the contracts with different talent management agencies. We have contracts with franchisees, leagues, and different teams or team brands, etc. Definition of celebrity and the struggle to fit these sports people into that. These are some of the clarity I'm seeking from the panel today. And what could be the legal repercussions apart from injunction? So are we also looking at damages for something like a reputational harm, or we are looking at disgorgement of profits which the wrongdoer might have made? We were talking about unjust enrichment in the previous panel. So what could be those kind of potential consequences, or is it something that we should restrict the solution to the contracts and make them more comprehensive? So with that, I would request Professor Michael McKeon to share how this all looks from the US perspective. We do have a Q&A session at the end, so I would just restrict this round of discussions to just understand it from the different jurisdictional perspectives, how all of this kind of comes from law.
Sure, and thank you for having me. Thanks for organizing this great event. It's great to see our law schools work together, and I know we'll be doing many other collaborations in the future. In terms of the U.S. and some of the issues that you referenced, as Pete noted, so much of it is based on state law, that instead of a federal regime overseeing these issues, we go on a state-by-state basis, and there are different remedies available under those state laws. Typically, the monetary damages vary in terms of what's set by state statute. In addition, the capacity of getting an injunction can vary by state in terms of the likelihood of that being met. Some of the laws are much more favorable for seeking an injunction than others, so that can have an effect on the remedies. We're certainly seeing these issues play out in the US in college sports. I think this is sort of in the United States, college sports is morphing into something more akin to professional sports. It's unique in the US. We have kind of our college sports are played by students who are full-time students, and yet they're playing on games that are broadcast on ESPN, on national TV. They have millions of people watching them, but they're considered amateur athletes. But that is shifting because of antitrust litigation that has said these athletes are actually not simply students, they're performing services, and NCAA rules, which member schools agree to, have constrained their opportunity for compensation. There was a big settlement over the summer that now allows colleges to directly share revenue with athletes. But what's really interesting for what we're talking about around publicity is we are seeing college students now suing to stay in school. They don't want to leave. They want to stay in school and make money as a college athlete, because now they can sign NIL or endorsement deals and also get a share of revenue. So it's a really interesting phenomenon. Traditionally, and I've worked on cases involving athletes that sue to turn pro. Now we're seeing people that don't want to leave school because they can make millions of dollars in some cases by staying in school. And of course, there are tons of graduate programs that permit people to stay in school for a while. The NCAA has a rule saying you can only play 5 years, 4 seasons in 5 years, but that's being challenged. So a lot of these issues are playing out in real time here at the college level. I think you're on mute. I think you're on mute.
Sure. That itself is very interesting because we have been reading about the NIL rights to college athletes, and which is very unique because we have not talked about something like that in India yet, I believe. And it's quite interesting that people don't want to leave school because of these kind of rights that they have. So I would like to move on and get some first-hand perspectives from the European Union or Spain from Professor Dev Kumar Parmar.
Thank you, Professor Anandita. And first of all, thank you to everyone for putting this event together. Am I audible, by the way?
Yes.
Excellent. Thank you very much. And just reiterating what my colleague Michael said from the States, no doubt this will be one of many, many events that we share across our institutions in the future. A couple of disclosures, if I may. The institution I represent today is a Spanish institution, and I'm honored to be in a position of a director there, and I have been now for the past decade. But at the same time, as you can probably tell from my accent, I'm not Spanish. I'm entirely English, and I'm an English barrister. So my legal training is all done in England and Wales. And from that sense, there's not much I can add value from the European Union perspective, apart from some of the bits of work that we've had to do cross jurisdiction. But what I can say, Professor Anandita, is that from an English and Welsh perspective, the challenges are quite unique in one sense, similar to what Professor Michael McCann had mentioned. We have a uniqueness in the States, we have a uniqueness in England and Wales, but that's where the similarity ends. Our uniqueness is based on the fact that we actually have a significant limitation of legislation with regards to many of these areas. And much like many other issues that can arise in English and Welsh law, much of our practice is governed primarily by jurisprudence, as opposed to by a codified piece of legislation or whatever. And then furthermore, of course, much like India and many other countries, we don't have this phenomena with regards to student athletes and the NIL situation. So when we talk about the celebrity economy or the sports celebrity economy and protections thereof within England and Wales, much of it is based on the common law setup, how they can be protected under common law. And essentially, we've got 4 different mechanisms to do that. First, we have privacy law, which can handle some elements. And I think you were touching upon it very briefly, Professor, with regards to initially it was just a case of being able to confine yourself or to conceal yourself and to see where access comes in. And then it's developed in so many different ways to also have a commercial element. So we do have privacy law. We have the common law concept of passing off to see whether an individual or an entity's goodwill has been damaged by a purported misrepresentation by another person, and if there's a monetary element that's attached to that. There are various other, let's say, smaller intellectual property rights that can be looked into. And then, of course, again, Professor, you touched upon it, contract. What do the contracts between certain parties actually dictate? What do they express? What do they also imply? Because our legal framework in England and Wales also enables a lot of implication, whereas in Spain, for example, the concept of implied term is something that's fundamentally different to what we have in English and Welsh law, and consequently in a lot of the common law jurisdictions, much like India and the United States and various other countries that have been connected to or part of our empire from historical times. So that's one thing I can tell you about European law in that perspective. We have a codified system in the European Union, which is totally opposite to what we have in England and Wales. So these are some of the things that we would look at when we start drawing into the issues that can arise with athletes and with institutions that host athletes within the English and Welsh system and a little bit further on in the United Kingdom. But all of this has developed massively in the last couple of decades. And this has been driven hugely by the advent of the internet, and of course the development of the internet with Web 2 and what we're seeing now and everything we're going to see in the future. Seamless access to information across borders, something we didn't really have before. So even where we might have had state-driven or country-driven laws to protect certain instances in certain situations, and then to handle the monetization of that issue if it ever arose, now we're finding ourselves in a position where these laws themselves, in some instances, are utterly inadequate. Where we have a unity in the European Union, we probably have a little bit more ability to cover the personality rights or to protect the personality rights of certain athletes, certain individuals across a couple of dozen countries. But again, it's only confined to one continent, because the personality rights of that individual or the image rights of that entity, for example, when it goes off to India or to China or to the States, we have to then cover different jurisdictions. So we're in very interesting territory for us as practitioners and as academicians. Interesting territory is quite good, if one can put it that way, because it gives rise to a lot of debate, and Professor Michael McCann also mentioned it, and something that works for us from a professional perspective. It also gives rise to a lot of cases. So from those perspectives, it's fantastic. But if we have to speak in a, let's say, a clear and linear way, we have challenges, and some of these challenges are not really helped by the fact that we don't have full codification in our system at the very least. And even if we did, with the way the society is now, I think we'll find it even more difficult to contain some of these issues. I don't know if that answers your question, because your question was about EU law and I went on my own tangent, but I hope that it covers some points in it.
That was perfectly helpful, because the kind of ambiguity that you're talking about in terms of common law is something we also share, like in India. And of course, there is always a tussle between that mix of statute and when to go for that statutory reference and when to go for the common law, how it has, the jurisprudence has developed. So that really helps. Coming to that, India also resonates that kind of a mix. And the travelogue, I believe, has been quite similar to that extent. So, Ms. Simran, I would love to hear from you as to how this puzzle unfolds for India and what kind of regulatory reforms could be expected for, like a better protection as a way forward, maybe. So if you could share your inside.
Thank you, Anandita. And it's Simreen, not Simran. That's on my
Sorry.
that's on my parents. So I'll bring the Indian perspective on sports identity and the law. So when we talk about publicity rights or personality rights in the context of athletes in India, it's very interesting and a paradoxical position. So on one hand, we have sports persons in India. So sports in India is mostly cricket, where they enjoy celebrity status. Their images, it appears on the billboards, on television commercials, and also on digital platforms like Instagram, YouTube, those reels. And on the other hand, the legal framework governing the ownership, control, and protection of these rights, it remains fragmented, and it's uncodified, and it's heavily reliant on judicial intervention. Now, if you were to look at the current position, the biggest problem is personality rights is not codified, and we are relying on judicial decisions. We can refer to the case of the 2003 judgment of Delhi High Court, which is where it talks about where the first right to publicity was actually recognized, which was different from it was separated. The court said that it is separate from copyright or trademark. And then the later case of Ramkumar Jewelers, where the commercial value of celebrity identity was recognized, because when you sell these, you have these billboards, and there is no permission. There's a lot of exploitation, especially commercial exploitation. So although these cases that I've mentioned are about Amitabh Bachchan and Jaya Bachchan, and they're not strictly about athletes, but they laid the foundation for what the sports person can then use to claim similar protection. These are very, very important steps, but like I mentioned, they do not come from legislation. They come from litigation. We can then talk about, I'm going to quickly touch upon fantasy sports and also the digital technology, which is the AI and deepfakes. We've had a symposium last year, so I think I'll bring in that perspective as well. So when we bring sports, let's talk about fantasy platforms like Dream 11. So the courts have held that fantasy sports are a game of skill, and therefore they are legal. But that does not resolve the question as to what extent these platforms can then freely use the player's name, their stats, and their images without consent. So athletes have no control over, no statutory right to control this. That's for the fantasy sports platform. The second layer of complexity is the digital technology with the deepfakes and AI technology. The likeness, you cannot differentiate between what is reality and where does the virtual world begins. And Indian law does not have a clear framework on whether an athlete can stop a company from cloning their voice or face. Similarly, with the case of NFT boom, it also raises fresh concerns in the sense that when you talk about iconic sporting moment, let's say somebody hits a six and that is tokenized and sold. So does the athlete have right to royalties? So the law at the moment is silent. And this creates a lot of regulatory ambiguity. The BCCI, which is the regulatory body, it is a private body, and so it does not have that kind of state status. And similarly, the Ministry of Sports has very limited involvement in commercial rights. So what are the athletes left to? They're left to rely on contract law, on tort law of passing off, or on IP law, but there's nothing specifically designed to cater to these situations. Now, if you compare this with US, like Professor McCain mentioned, there are NIL reforms that empower these college students to monetize their name, their likeness, and their image. And similarly, like Professor Dev mentioned, that in EU, you have personality right, and there is data protection framework, which provides statutory safeguards. India, by that contrast, it operates in a patchwork system, if I can call it, where disputes are often settled through long drawn litigation, or they're settled privately. So, and I will answer your question where you said what could be the reforms that we can then look into. We can certainly look into codification, where there is a separate statute, or there are where there's recognition of these publicity rights, or a clear insertion into IP law. Then we can talk about, we can have digital regulation, which is there can be a consent and licensing framework. So the athletes can then negotiate fairly and, sort of avoid or prevent exploitation. And of course, this comes, Professor Peter had mentioned that you have to balance that with, the public interest of, then you cannot, we still need news, we still need commentary, we still need satire. So that has to always balance. And but when it comes to commercial gain, athletes' consent, I think, must be central. I hope I've answered your question.
Yes, definitely. So we'll try to gather the cue from the first round of the discussions that we have had. And a couple of questions came to my mind as I was listening to all the esteemed speakers. One is that how do you try to balance the athlete rights and something that could be now evolving as a personal data right of athletes, particularly considering that in India also we are looking at a data protection law to soon come up, vis-a-vis when we allow the use under the aegis of public interest or legitimate interest or non-commercial use. So it would be helpful if Professor McCain can share some light on that.
Sure. So in the US, the First Amendment plays an important role because it provides, it makes statistics, for example, part of the public record. And an athlete would struggle in court to argue that he or she's, their statistical performance is somehow a protected interest that they own because of the fact that it's a public record. And there has been litigation over that. There was litigation years ago brought against a fantasy sports company that used the statistics of Major League Baseball players without permission. And ultimately, the court said the First Amendment's a robust protection. Statistics are in the public domain. So those cases have typically led to lack of protection, you could say, for the individuals. Now, it would be different if the likeness of the athlete were used, or their image, or their name, or if they have a distinctive signature, or something along those lines. Even a nickname has been held as protectable. And there was a famous case years ago involving Johnny Carson. He was the late night talk show host, he was big in the 1980s. And there was a toilet company, a portable toilet company, that created a line called "Here's Johnny." "Here's Johnny" was the phrase used to introduce Johnny Carson onto his show. And Carson sued, even though he didn't actually say it. It was a sidekick who said it. Even though John is a very common name in the US, he was able to win under a right of publicity claim because it was so commonly linked to his identity. One topic that I think relates to this a little bit is, what's going to happen with AI and particularly deepfakes when we have deceased, imagery of deceased people appearing. Like do their family, through wills and estates, do they own the right to use great granddad in a commercial? I mean, there's some really interesting issues about whether or not these rights continue after death and who ought to control them. There's in the United States, the right of publicity varies by state, as Peter mentioned, and it can vary by a period of years. But one of the sort of issue that has led to litigation in the US, particularly involving famous musicians who pass away, whether it's Prince or Michael Jackson, is sort of use of their identity after dying and family disagreements about that. So I don't know, to both of my colleagues' comments, I mean, a lot of this is unresolved, and there isn't sort of a bright line answer to many of these issues.
Yes. Just to follow up on that, like this is looking at from the athlete's perspective. What if I look at it from the brand or the company perspective? So, say there is an endorsement arrangement between a person, an individual, and a company. And it's not that the company is misusing the personality right, but it is the individual's conduct which might, uh, you know, build up or tarnish the image of the brand at times. So that kind of an equation, how is that dealt with? It's kind of a reverse of the personality rights that we are talking about.
Sorry, yeah, no, I think that's exactly right. It certainly does seem like a reverse in that respect, but I think similarly there's a lack of certainty in what the law is, and part of it's the law is catching up with technology, right? I mean, this AI is brand new. AI is evolving. Seems like it gets more advanced every week. We read about new findings in AI. And candidly, sometimes they're a little scary, right? When we think about AI's impact on the job market and opportunities for people to work. I mean, there are a lot of legal issues that I don't think we know the answers to and won't be resolved for a while. And even if legislatures intervene, some of what they do might be antiquated within a year or two, depending upon the rate of technological change. So I think this is where courts need to be really nimble, need to be really up to date in being able to respond correctly as changes happen.
Right. Just breaking that order, I'll come to Simran. Simran, for the reason that we were just talking about, courts keeping up pace with the change of law and the statute. So in India, a lot of it comes from contract law, and we have seen, of course, that we have a legislation of 1872, which probably obviously did not foresee the challenges that we see in the contemporary, AI and sports world. So my question is that, is there anything that needs, apart from the statutory codification that we have been talking about, anything that India can do, learning from the international examples, to bridge this gap or the pace between, the practice and the regulatory framework, but of course, subject to the Indian context?
Thank you for that, Anandita. So you're right. The only legal framework that's governing sports in India and the agency contracts is ICA, which is as old as 1872, and particularly the section 182, which is on agency. That's where these contracts draw their path. But honestly, it's far too general for realities of today's sports economy, especially cricket, which is not just a sport in India, it's a multi-billion-dollar business. And yes, and the risks are clear. Athletes, especially the younger ones, are often left vulnerable to unfair contracts, to conflicts of interest, to misuse of personality rights, their name, image, and likeness, because there's no dedicated legislation to protect this. And now, other countries give us good models, and not just that, the Lodha committee also had recommended that there should be accreditation for cricket agents. But the BCCI has not enforced it. So there's something that has been recommended, but that lacks enforcement. Internationally, for example, the US and the France, they have written contracts which lay down the clear terms, and that's something India could adapt. Another safeguard could be, to have regular audits of financial dealings, which could be overseen by a committee which is independent, but within the BCCI. So the point is, while the Indian Contract Act does give a legal base, it's inadequate for the stakes involved. And if we borrow from these global best practices and adapt them, we could create a system that's much more fairer, more transparent, and that actually protects the athletes from exploitation.
Sure. Right. Professor Dev Kumar, we've been talking about leagues. Considering that you have your experiences with the Indian as well as the English league, I had read it from your profile. So could you share some insight on whether the Indian experience and the English experience, how different was those, and could we have some kind of a base or a minimum standard which could converge the regulatory framework globally, or should it be just leave it to country-specific nuances here?
No, thank you, Professor. Two very loaded questions, so I'll do my best to provide a cogent response, let's say. So we're very fortunate in our practice where we work quite widespread internationally. So the sports leagues in England and in India are just two of the jurisdictions that we've had the ability and the opportunity to work with in. But if we take those two alone and we look at football, because I think when you might have been reading the profile, you might have been reading about the work that we did in the Indian Super League in association football when it started 12 years ago now, I think, more or less. So what we found there, before we go into the rights issue, but just to give you all a very quick bit of global context, what we found with the Indian Super League was the intention and the idea was fantastic. Where the execution struggled a little bit was the desire to replicate the English Premier League model to a certain extent, and then to replicate the MLS model from the United States to a certain extent. And what we found in reality was a bit of a mishmash. So then that kind of ties into your point, the second question about keeping things to countries' own laws and their own cultural norms and nuances. What we found was this desire to copy good practices, which is not bad, it's something that we try and encourage in academia and in practice a lot of the time, right? Look at good practice and try and aspire to it. But it was done in such a linear manner that it just became a straightforward copy and paste. And as we know, copy and paste governance never works in whichever instant we're looking at it. So that in itself gave a number of different challenges. However, one of the good things that I think it did do from an institutional perspective when we're talking about rights and issues surrounding rights was it sought to centralize completely how rights will be utilized and where there can be monetization of those rights and where there can be separation of that monetization. So essentially, the league has the ability to utilize the image of any of its participants, should it wish to do so, as soon as you sign the contract, of course, to utilize the image of that participant, as long as the image of that participant is within the context of the tournament, right? So if it's within a game scenario, within a game preparation scenario, so it could be walking into the stadium or walking onto the field of play, whether it's in context with the attire, be it match day attire or training attire of the club or the franchise that individual is representing, or the clubs themselves, that can all be utilized by the league as and when it wishes. Anything outside of that is now a different story. Now, of course, that line can shift to a certain extent depending on the individual. It would be fundamentally different for, let's say a good but maybe not a global elite player. just thinking of names because I don't want to offend anyone that supports a specific team. But let's just say a Premier League player in England right now, who's a very high quality player, earning millions of pounds per year, but not a global name as opposed to someone like a Cristiano Ronaldo. So that line will always shift, but essentially the leagues seek to entrench all of these things into contract, and it's quite straightforward. We have the right to do whatever we want within this sphere. Outside of that sphere, you can do what you want, and then other agreements can be put into play. And sometimes those agreements might have to work in line with the league agreement and the club or franchise agreement, depending on which country you're in. It's a club or a franchise. But if you don't want to adhere to that, no problem. Don't sign for the club. The simple reality is we've got a truckload of players of a similar quality that we can bring in. Now, it sounds very crass, but at the end of the day, that's essentially where it gets to, because there are so many athletes that aspire to get to this level. There's so much competition, which leads to let's say a bottlenecking of talent to a certain extent. But the reality is, if one person doesn't want to be participating in that league, in that tournament, with that club, with that franchise, they can quite easily find another one of a high level. So the leagues and the tournaments tend to protect this quite strongly. Now, if we go on to uniformity across jurisdictions, I think the utopian view would say, yes, why not? Absolutely. The practical view is going to say this would be a disaster. I don't think we'd ever get to that stage in the first place. Now, I mentioned in my first intervention that you kindly invited that some of the challenges we have with regards to personality and things like that in England and Wales stem from the fact that we don't have codification. Now, I don't say that in a binary way that we must have codification and that's going to solve all of the problems. I think it's there to try and improve some of the stuff that we're going through, which other countries might not be seeing. But having a unified legal system on this, even if we narrowed it down as much as possible to a specific industry or to a specific discipline within that industry, so sport and then down to association football, or to gridiron, to American football, to cricket, whatever it might be. All of these disciplines are either played or consumed cross borders. And straight away, we've got different laws, different regulations, different cultures, different norms, different languages across the globe. I think it'll be very, very difficult to try and harmonize something like that. So yes, in theory, it'd be nice that everyone has the same standard. But even if we narrow it down to a certain discipline, let's say cricket, because football is so widely spread. Let's say cricket, because essentially it's still an empirical game, right? We're still having to deal with cultural norms and nuances and laws from India, Australia, New Zealand, South Africa, the entire Caribbean spot, and now with the advent of the Major League Cricket and how well the USA did in the last one-day World Cup, the US. It's a nightmare. I don't see us ever having that, even if we try to narrow it down to a sector. So great idea, but sorry to end on a negative note. Don't think it's going to happen.
No, thank you so much. We've had some brilliant and wonderful practical experiences, insights being shared here. A lot of responses and a lot of more open-ended questions that are actually coming up from those responses. Like we have so many questions now in our mind, which needs to be resolved and needs to be answered, and of course, which cannot be done over a single panel. Simran, are we doing a Q&A? Do we have?
I don't see questions in the Q&A, so maybe you can invite Professor McCain for the closing remarks.
So in that case, I would invite Professor McCain, if you could please have your closing remarks for this wonderful panel that we had today.
Thank you, Professor. I mean, what a great two panels we had today. Excellent discussion. I learned a lot, and I know everyone else did as well. I think what we've seen is that countries have varying approaches to rights of publicity, how to protect them, how to prevent others from exploiting them, and different remedies that are available when that happens. We've also seen that there are variances in terms of whether common law is applicable, whether or not a statute applies, or the use of contracts is also relevant in terms of provisions. And I think to Professor Dev's comments a few minutes ago, it's tough to come up with one system when there are varying arrangements of laws and customs as well that will limit the ability to come up with one set of rules. One thing that I intended to mention before is that one big issue in the US is the role of unions, that unions can represent athletes and come up with contractual approaches that create more uniformity. It's not a perfect approach because endorsement deals, as we all know, are really about the athlete, and they're often outside the scope of any sort of collective bargaining agreement. But nonetheless, that is one way of trying to shepherd through some of these complicated issues. I think issues of deepfake, AI, the sort of rights of those who have passed away, what happens to their identity, their fame when they're no longer here. These are really hard issues, and I would just end by saying it's important to have discussions like this, because I don't think we can rely on governments to figure these things out. I don't think governments act quickly enough. I don't think they're as responsive to changes in the marketplace. And some would say academics aren't either. I don't know. I think we're more attuned to following what's going on. And we're also, of course, part of the legal system and participating in it. So super interesting discussion. There aren't necessarily answers, but there are questions that are provocative that will lead us to other questions and other ideas. And I hope we do another one of these events soon, because this was excellent. Thank you again.
Thank you. Thank you to all the panelists, and thank you, everyone.
Thank you. Bye-bye.
We'll end it. Thank you.
Thank you very much. Have a good day, all. Thank you.
Yep.
Bye-bye.
Bye.